Good morning, good afternoon, and how is everybody today? And welcome to the second in the series of Independent Contractor Compliance and Engagement Enterprise Solutions webinar series for MBO partners. We have a great program today with two exciting guests that are experts in this field. So I'd like to get started as soon as we can. A couple of quick housekeeping items. This being our second webinar, I'm noticing a lot of repeat customers coming back and taking a look at our program, so I'm looking forward to catching up with all of you. If you have questions, there's a section down at the bottom on your screen that says questions. Please ask them there. Everybody is going to be muted during the webinar. So first of all, I think the most important thing that we could talk about in this initial webinar intro is the fact that there is a tremendous amount of interest and engagement with independent contractors, and many of our clients and a lot of people that I've spoken to over the last several months have been asking about how we stay in touch with all the changes, not only in legislation, but in just some of the case law and some of the trends that are affecting independent contractors. So we thought it would be a good idea to bring together some experts, ask a couple of key questions, get their honest input, and see if we can help shed some light on some of these things that may not be clearly published or, for that matter, expressed by state, federal, and the other authorities that are affecting independent contractor engagement. So let's start with, my name is Jay Lash. I'm the market strategist for MBO Partners. I'll be the host, and let's make a couple of introductions. So first of all, we have joining us Steve King, who's a partner with Emergent Research. And Emergent Research does a lot of research on small business, the economy, work for Department of Labor and some other government agencies, both in understanding the use of small business in today's economy, but also those trends that are affecting it. Steve, welcome.
Thanks for having us, Jay. I'm looking forward to this.
Good. And second of all, we have Mr. Eric Rumbaugh, who is an attorney for Michael Best and a leading authority in independent contractor engagement. He is most definitely one of the leading experts in this field and follows not only the independent contractor, but more or less contingent labor in general and how it's affecting this workforce. He's also a prominent attorney dealing with cases, actually, that do, in fact, emerge in this space. So, Eric, welcome.
Hello, Jay Lash. How are you?
I'm very well. Good to have both of you guys join us today. And again, questions as they come up, please enter them on the questions section, and both Eric and Steve will take questions during the panel discussion. So let's get started right away. We have the most pressing issue, I think the one that probably gives a lot of people on this call a little anxiety when they think about the upcoming Affordable Care Act. With that Affordable Care Act, I think everybody knows we are just getting started, 2014. Many of these laws and the various controls that are going to be in place will get started, but nobody really knows how it's going to take effect. So let's start with Eric, perhaps. Eric, maybe you could give me an idea as to what high-level demands the new law might have on the effect of independent contractor engagement, and just give us a, sort of your general perception of how this law is emerging.
Well, the Affordable Care Act, as regards independent contractors, is actually pretty simple. And I'll talk about that in a second, Jay. But I've been surprised at, and maybe I shouldn't have been, but I've been surprised at how much more attention IC classification has gotten since the Affordable Care Act. And I don't know why that is, because IC classification was a hot-button boilerplate issue 2 years ago, and the Affordable Care Act does raise the stakes on IC classification, but for some reason this is good for me. I'm able to get people's attention, my client's attention, and get people to be more serious about IC classification post-Affordable Care Act. So what does Affordable Care Act do, and how is it different? And it's different in kind of an intriguing, idiosyncratic way. We've talked for years about the fact that there are different tests for IC status, and someone might be an independent contractor for purposes of one law, but a state unemployment compensation or workers' compensation law might have a different test for IC status. So someone might be an employee under one law, but an independent contractor under another law, which is a complicating factor for IC classification. We've also talked about the fact that a lot of mechanisms that people use, that businesses use to avoid IC classification problems really aren't effective, and that one of the steps that's effective is to address benefits liability through defining eligibility for people in your plan. In other words, if you misclassify somebody as an independent contractor and don't include them in a retirement or welfare plan, you're okay if you've properly defined the person out of the plan and you've reserved your plan administrator the ability to make, given them a high-level decision-making authority over who gets into the plan. In other words, the law defers to the plan administrator if the plan's drafted properly. So dealing with IC classification issues in many cases include, as a big issue, defining eligibility in the plan. The Affordable Care Act stands that on its head. The Affordable Care Act uses one test. It uses the common law test. And it presumes that people who engage contingent labor, that the staffing supplier is the common law employer of contingent workers. Obviously, for independent contractors, nobody's the common law employer if workers are correctly classified. But businesses need to realize that if someone is their common law employee, even if they are engaged through someone else, even if they're paid by someone else, even if they're there through a staffing supplier, and regardless of how you've characterized them in contract or characterized them in your plan, you have a pay or play duty for that independent contractor. So the ability to delegate duties to a vendor, the ability to limit liability and regulate liability through defining eligibility in a plan document is gone. It still exists for other laws, but for the Affordable Care Act, it doesn't exist. If someone is your common law employee using the common law test, which we'll talk about in a little bit, you have a pay or play duty for those people, and you can't define it out, and you can't contract yourself out of it. And that's creating a lot of problems for people, and it's really up the stakes on correctly classifying independent contractors.
But it has made it a little bit more complicated for staffing firms and maybe for their clients. So it's possible that a client can be held accountable for not providing health benefits for an IC. Is that true?
Under the regs as they currently exist, the duty to pay or play follows the common law employer. And the law presumes that a staffing supplier is the common law employer. However, every year there are a variety of cases where courts find that the staffing supplier isn't the common law employer. Not only is there not common law employment, but or co-employment, but the staffing supplier isn't an employer at all for various legal purposes, even though it's withholding taxes and paying unemployment and workers' compensation benefits. Because the staffing supplier, in many cases, doesn't exert any management, direction, or control over the workers that it's supplying. All the management, direction, or control comes from the client. So under the regs as they currently exist, in those cases, the client would have a pay or play duty for contingent workers, even if the staffing company is providing minimal affordable care or paying a penalty. We're expecting regs to be drafted that would clarify that a staffing supplier can meet their client's Affordable Care Act duties through providing benefits or paying a penalty, but right now those regs don't exist.
So it puts a little emphasis on the co-employment dimension of a staffing and staff-employee relationship.
Yeah, in most cases, a staffing supplier can delegate many or almost all of its duties to its, or excuse me, a client can delegate many or almost all of its duties to its staffing supplier. We expect that to be the case under the Affordable Care Act, but right now it's not.
Are you seeing the fact that there may be a time in early 2014 perhaps where some of these come up to cases that will then determine a ruling giving more clarity, or do you think these regulations will be drafted early next year?
I wouldn't hold my breath on getting regulations drafted in the next 6 or 8 months. I mean, we desperately need them businesses, especially buyers and suppliers of contingent labor, desperately need these regs, but we don't have them. The key, that's one self-help thing that businesses can do, or one and then 1A that businesses can engage in right now in the area of independent contractors. This doesn't apply so much in the area of contingent employees, but in the area of contingent independent contractors is one, to wire yourself down tight in terms of correctly classifying people, and two, and this is more nuanced, where you've got independent contractors who might be misclassified, who are on the edge of the knife, whether they're going to be employees at all, you can knock them out of the Affordable Care Act and lots of other things by actually engaging them as independent contractors, and you don't have to play the ball where it lies. Now is a time that businesses can engage in proactive steps to basically deal themselves the cards that they'll need if they're ever called on the IC classification status of their consultants. For instance, if you're paying people on an hourly basis, you could switch yourself to paying workers on a per project basis instead of on an hourly basis. Instead of paying workers a rate and then reimbursing expenses, increase the rate and don't reimburse expenses. These are all factors that would increase the chances that a consultant is actually found to be an independent contractor and would take away not only Affordable Care Act problems, but a lot of other problems.
So it does sound like the Affordable Care Act may not be changing the way independent contractors engage, but maybe putting a little bit more clarity on the fact that they should be engaged properly in order to avoid, if you would, being held accountable.
I would phrase it this way. Businesses have been skating, or let me back up. Every business is on some spectrum in terms of how seriously they take IC classification. Some businesses are very sophisticated in terms of their IC engagement mechanisms. Some are somewhat sophisticated but are taking it seriously. Some realize that there's some hypothetical problem out there, some existential problem, but they haven't seen it come to roost for them or their industry, so they're just kind of waiting.
Yeah.
And the Affordable Care Act is another one of those magic moments in history of the law where everybody goes to a seminar or goes to 7 seminars and everybody takes it really seriously and it ups the stakes. So you get a whole new set of ears within an organization hearing that IC classification is a really big deal because of the Affordable Care Act. And it's not the same old people who've gone to the same old seminars. It's different ears. And so when somebody rings the bell and says, hey, there's a problem here, I've found a greater willingness of organizations to take it seriously and to think creatively to take proactive steps to stop the problem.
New audience looking at the same old problem. Hey, Steve, let's ask you just in terms of the economics of this law. Do you think and do you expect that companies might be using ICs more to avoid the 50-employee threshold? And do you see this as an instigator, inhibitor to small business growth in the future?
Yeah, we're in the conversations we're having with small businesses, particularly those that are near the 50-employee threshold. A lot of them are trying to figure out what's going on, and quite honestly, the vast majority of small businesses today are totally confused by this. So there's an enormous amount of confusion. Nobody really knows what they're supposed to do yet. And I think that leads to a lot of people thinking, well, then I should definitely plan for the worst case. And because of that, we're seeing a lot of companies take a variety of paths. We're sort of seeing the idea that they're going to outsource more stuff to stay away from the 50-employee limit. Certainly use more ICs, use more freelancers, use more independent workers to also try to avoid that limit. And the one that's getting a lot of play in the press is the use of more part-timers. And I think that's kind of an interesting one in the sense that the percentage of part-timers in the U.S. economy has gone up quite a bit over the last decade. There's about 27 million of them today. And about 10 million of them, according to the BLS, work right around that threshold of 30 hours a week that differentiates for ACA between full and part-time employment. And there's a lot of technology that's allowing companies to move to more part-time employment. So I think we'll see all of those efforts. There are a number of European countries that have small business laws, interestingly enough, at the 50-employee level. And what you find in those countries like France, is that there are a lot of companies with 49 employees, and then very few companies until you get to about 80 employees. And I think we're going to see a similar thing happen here in the U.S. because of this.
So kind of a line of demarcation between the true smaller business and then what is an emerging large business.
Yeah, and then to get to your second part of your question around, will it drive more small business growth? We actually think it will, particularly very small businesses, micro businesses with just a few employees, and then more independent businesses, solopreneurs, what we call independent workers, the freelancers, the independent consultants. And that's going to be driven because health insurance will be available and affordable, we at least hope. It is too early to know that for sure, but certainly we're hoping that will happen, and so it'll make it easier for these folks to get insurance, and the economists call the lack of benefits going independently job lock, that you're locked into your job because you can't get benefits. And when you actually look at the small business universe, for employer small businesses with less than 50 employees, about a quarter of the owners themselves don't have health insurance. About 50% of those companies provide health plans of some sort or another to their employees, but even given that, about a quarter of the owners don't have health insurance. And then when you look at independent workers, these independent consultants and freelancers, about a third of them don't have health insurance. And so we're going to see those people, one way or another, end up with health insurance due to the mandates. And for people looking to start small businesses, they'll be able to look out there and say, I don't have to worry about job lock. And so we do think it's going to lead to more small businesses.
Okay, interesting. Steve wrote a really interesting blog a little while ago, and we posted it on our website. So if you get a chance, anybody in the audience want to deep dive into that whole job lock idea, it is on our website. Let's switch gears a little bit. Oh, go ahead.
Let me just add one other thing.
Yeah.
The last piece is we do think there'll be an enormous increase in the number of small businesses organized around helping people figure this out. So there's going to be a strong growth in consultants and service firms that help companies and small businesses in particular try to figure out how to handle the Affordable Care Act, because it's complex and it's confusing.
There's a tip to the audience. But like year 2, Y2K problem, all of a sudden there were also Y2K consultants. Now we have a new ACA consulting binge coming up.
Absolutely.
All right, well, let's switch gears a little bit here, and I'm going to switch this back to Eric. Commonly, we hear of legal cases that hit the public eye through the media and news journals, and some of these, the active ones like a FedEx case or Microsoft or Walmart cases, may get a little bit more press than others that get settled out of court, or for that matter, get into a class action situation. They never make the headlines. But some of these cases actually have a fairly significant benchmark result on how future cases will be ruled. So let's turn to Eric for a second and see if there are any cases recently that you might think have an impact on IC engagement. Any come to mind, Eric?
Yes, Jay, and I'm going to talk about some cases, and people may think that that this is funny, and it may sound funny, but it's dead serious. There's a series of cases in 2010, 2011 that have spawned another series of cases dealing with the independent contractor status of exotic dancers. And these are independent contract, or the question is, are these people independent contractors? And these are wage and hour cases. So I said earlier that the test for, there's multiple different tests for whether someone's an independent contractor or an employee or not. In many jurisdictions, the test, and for federal cases, the common test for determining whether someone's an independent contractor for wage and hour purposes is different than the IRS test, it's different than the common law test. It's called the economic realities test. And what the economic realities test, I'll go through the factors in a second, but what it really tries to get to is this person really, as a matter of economic reality, dependent on the entity that they're working for? And dependent in an entrepreneurial sense, in a management direction or control sense, in all the senses. And so the question is, are exotic dancers employees or independent contractors for wage and hour purposes? And I'll talk about the economic realities test in a second. The interesting thing is, as you go through other cases following these exotic dancer cases, you find the exotic dancer cases cited. The exotic dancer cases, despite the fact that they're on a topic that probably doesn't apply on its facts to any of the people on the call, I hope, in reality, the test that's applied is the test, and the judges in several of these cases, and there's a series of them in several states, really apply kind of a scholarly method to analyzing the economic realities test as applied to dancers. And I actually, in reading them, I know much more about the exotic dancing business than I knew before. And other courts are applying this reasoning to other fact patterns, which I'll talk about in a minute. But the economic realities test has several classic factors, which are, first, the nature and degree of the alleged employer's control as to the manner in which the work will be performed. This is the factor that's common to basically every test for independent contractor, whether it's a state unemployment test, a state workers' comp test, IRS test, a state fair employment law test, whatever the test is. One thing that everyone's got in common is who controls when, where, and how. And it's interesting, when you read the dancer cases, the clubs where these people dance are saying, hey, they control a lot of their job. And I won't get into the details, but a lot of the aspects of how dancers dance and when they dance are actually controlled by the dancer. A lot of other aspects are controlled by the club. So each side points out the factors where they control and where they don't control. Takeaway for people who are on this call who are worried about Affordable Care Act or any other type of classification, a lot of times the people who engage in independent consultants want control. And we put recitations of control into our contracts, and we make people recite that they'll follow this rule or that rule. If we want to be serious about reducing our IC classification risk, we have to give up control. So if you really want to control the when, where, and how of somebody's engagement, don't wonder why you have IC classification liability. Give up control. Give someone an end result and say, you have to produce this widget for me by this date, and leave it up to them to decide when, where, and how they do it. The more you tell them about, the more detailed your direction to them about when, where, and how they perform their work, the more likely it is that they're going to be found to be an independent contractor. And courts will recite that there's a multi-factor test and no one factor controls. In reality, for many courts, in fact, the majority of courts, this one factor predominates. If you control when, where, and how someone does their job, especially if you've given them written instructions on how to do it, that factor dominates the other factors in the eyes of many courts and determines whether the person's an independent contractor or not. The second
behavior control then seems to, in a sense, trump a lot of the other, at least three-factor test, financial risk, and go ahead.
And some courts will say no one factor controls. Other courts will come clean and say, hey, there's a bunch of factors, but we think that the manner and means of control test predominates. But in any case, it's by far the most important factor. The second factor is the alleged employee's opportunity for profit or loss. And again, if you're serious about engaging people as independent contractors, think about, could this person lose money? There's two things you can do in your engagement model that can move the needle. One, don't guarantee payment. Two, don't pay based on time, pay based on the job. Three, don't reimburse expenses. If you think you want to pay somebody $10,000, $8,000 in a fee, and you're guessing $2,000 in expenses, don't pay $8,000 and then reimburse the expenses. Have the fee be $10,000 and have the consultant responsible for their own expenses. That's how you can have somebody have an opportunity for profit or loss. They might not get paid on the job if you don't guarantee payment, and they might conceivably have expenses that are greater than their revenue. So you need to have them have expenses that they're responsible for and they're not getting reimbursed for. and you need to have some opportunity that they don't get paid for the job. That's the key to that factor. The next factor is the alleged employee's investment in equipment or materials for their work. Sometimes you have consultants that really don't have any investment. Sometimes some people are working from home and all they have is a computer, and maybe the computer is the investment. A lot of times when you're litigating these cases, the factor that you focus on and you recite like a Greek chorus is insurance. Think about requiring consultants to carry insurance. It is sometimes the well that you go to over and over again to meet multiple factors in terms of opportunity for profit or loss or investment. You need to have them have some investment, and then you're going to compare your investment in this job to their investment in this job. If they've got nothing on their side of the ledger, that's going to militate in favor of them being employees. The next factor is whether the service rendered requires a special skill. I think in the answer cases, it's interesting how courts discuss the type and degree of skill required, but I think most courts have found that the special skill required factor militates against dancers being independent contractors. The degree of permanency and duration of the relationship. The longer you engage someone, the more likely it is that they're going to be an employee, not an independent contractor. If you engage people by the job, and when they finish that job, they might or might not get engaged again, that militates in favor of independent contractor status. To the extent to which they're just have an open-ended engagement, that militates in favor of employee status. Then another factor, and this is a factor that shows up in some state tests, the extent to which the service is part of your business. So if you are an HVAC contracting firm and you're hiring someone to do HVAC contracting, the fact that the service they're providing is part of your service that you sell, that is a factor towards finding whether the person is an independent contractor or not. If you're a law firm and you hire an HVAC consultant, you're not selling HVAC consulting. The fact that they're providing a service to you that's outside of your services would militate in favor of that person being an independent contractor. So it's harder to have somebody be an independent contractor if they're selling the same thing, that the service or product that your company sells. So the answer cases apply these tests to a variety of fact patterns in several different clubs and come up with scholarly analysis which other courts are plagiarizing.
So obviously if a club serves drinks and food, their core business can be clearly not that of dancing. Dancing could be a sideline entertainment factor like betting or pool tables.
That's
could be
the argument they try to make, Jay, and the courts just weren't buying that argument.
They weren't buying. Oh well. We'll go for that. Judges probably don't get out too much, so that's probably one of the reasons. Anyway, let's check on another aspect here, and that's the recent legislation. Anything that comes to mind from either of you that might be recognized as recent legislation that has been passed?
Well, state by state, different states adopt different tests for employer independent contractor status. And states have different initiatives designed to check independent contractor status. The test that's being aped by other states and isn't new, but continues to create litigation problems is the Massachusetts ABC test. We took the last factor from the IC engagement test, the economic realities test that we just talked about for wage and hour cases. That is this function one of a core element of your business? That's the B part of the Massachusetts ABC test. So it's very hard to engage someone as an independent contractor. It's basically impossible to engage someone as an independent contractor if they're doing something that's core to your business. So if you're an accounting firm, it's almost impossible to hire an independent contractor accountant in Massachusetts. And under federal law, it would be tough to hire an accountant as an independent contractor.
Yeah, but not as much as
if you're an accounting firm.
Yeah. Now, does that seem to correspond with other states taking off on the same, or is it Massachusetts only right now?
That's Massachusetts, but other states are, there's a federal initiative and one of the federal initiatives is several federal agencies have an initiative to try and catch independent contractor misclassification, and the one that has the greatest impact is that state unemployment agencies, when they detect someone who's misclassified, they're supposed to flag other federal agencies. And we've seen for years, even before this initiative, the greatest source by a huge factor of challenges to IC status starts with an unemployment compensation claim. Someone applies for unemployment compensation benefits, maybe not even from your company, but during their intake at the state unemployment agency, they disclose where their incomes come from in the last 5 quarters. And if they disclose your company, the state agencies are trained to flag instances where someone gets paid as an independent contractor and think about investigating them. And if a state unemployment agency investigates IC classification and finds a problem, they're supposed to tell the U.S. Department of Labor and other agencies. So paying unemployment benefits is a big deal towards avoiding scrutiny, but also be aware of how you interact with state unemployment agencies. That's by far the greatest source of challenges, and with this federal initiative of having agencies share information, it's the greatest source of information sharing between agencies.
You know, at MBO, we have seen that is true, that many of our clients have approached us after being audited by a state agency, and the state test does differ from the federal test, and it is, in some cases, widely different, like you were saying, in Massachusetts. And I think the key there is that the question from the unemployment office is not who was your last employer. It was where did you last generate income, and that income could be through an independent contractor relationship. So it isn't so much the IC who's telling on their prior clients, trying to get them in trouble. It clearly is the way in which they choose to file for unemployment, if in fact they do. So I'm going to keep things moving along a little bit. I know we've covered a lot about the current testing, and will there ever be a single test? I think you've done a lot to help us understand that there may be some time, but nothing coming up too soon. But I want to switch a little bit to something that I've read recently, and perhaps others in the audience have, and that's a Department of Labor survey that has just gone out in mid-March, early March, to about 10,000 registered individuals that have filed as independent contractors in prior years. And it's going to be asking them how they perceive their responsibility and obligations, or the effect of being independent contractors will have on their relationship with their clients. And what I'm getting is a lot of feedback from people saying, what the heck is this going to be used for? And more specifically, has this ever really been done before? And Steve, you study small business. You work with the Department of Labor and Bureau of Labor Statistics. What do you think about this survey? And do you think there's any chance that it's going to have a major effect on how things are perceived?
Yeah, the Department of Labor, there's been a lot of calls for the federal government agencies in general to better understand the role of contingent workers and independent consultants in the economy. And that's obvious because of the growth of that sector. And so the Department of Labor has decided to take on this study to better understand how independent consultants and contractors view themselves and view their employment relationship. And honestly, they've put out their draft survey document for comment and feedback. They put it out in January with feedback due back in March, and now they're fiddling with a second round of it. They're going to try to field the survey later this year. It was clear from the survey document itself that the goal was to find problems. It was those of us that work with government agencies were actually very surprised by the survey document. Normally, the best survey research in the world is conducted by our government. I mean, the Bureau of Labor Statistics, the census, those are the gold standard methodologies, and this one was clearly biased towards trying to uncover problems and create problems where there probably weren't problems. So they got a lot of feedback to that, and I have to say my feedback was that maybe it's not a good thing for the Department of Labor to do. It looked a little politicized to me, that they're trying to find issues where they don't exist, and I'd rather see one of our statistical agencies like the Bureau of Labor Statistics, which not only has experience surveying surveys of this type, but is also sort of immune from the political issues that that infect Washington. We don't know how it's going to turn out. There's kind of a fight going on right now over this survey and how to adjust it so that it'll be a more neutral survey to make it more accurate. But to me, it sort of makes the Department of Labor's intentions clear on this topic, which is they don't like the shift to a contingent workforce and the growing numbers of independent consultants.
And you've never seen an agency, the Department of Labor specifically, do something like this in the past, have you?
The last survey that sort of fit this description, the BLS, Bureau of Labor Statistics, did one in 2005, a more detailed look at what they call the contingent workforce, and actually contained a lot of similar data and questions, at least at the scoping side and the sizing side. There's been several other smaller studies trying to understand, again, sort of the breadth and depth of the numbers. I haven't seen anything that goes as deep around asking independent contractors and freelancers and such their views on the topic coming from the government. And that's kind of, our statistical agencies usually are focused on sort of size and numbers and such, and less on
quantifiable facts.
Like and less on the softer side. So this is very unusual in that sense.
Yeah. And I think the way that I understood it is they wanted to see if people truly, as independent contractors, truly understood the fact that they weren't employees and not being protected through the typical Department of Labor and Fair Labor Standards Act jurisdiction. So maybe it's going to be enlightening for the Department of Labor. Maybe it'll just be a nice new trigger for other agencies to find independent contractors.
Yeah, and there were actually a lot of good questions in the draft survey document. I was, and a lot of good information would come from it. You just want to see, anytime you see a survey that opens up and is clearly biased one direction or another, as a researcher, you're just disappointed in that, because then that throws in the validity of all the questions, even the good ones.
So let's switch gears again, and maybe while we've got Steve speaking, let's talk a little bit about this whole drive towards independent contracting and the movement increasing not only from an independent contractor standpoint, but companies using independent contractors. It's clear, as you're saying, the government's now more aware. They're not getting perhaps the withholdings and the revenue from withholdings that they were looking for. The administration, the Obama administration, is very pro-labor, pro-union. There seems to be a lot more activity that's focused on keeping that movement going, and the independence movement is a little bit contrary to that. What do you see as, number one, the greatest driver, let's say, that has led to the increase in independent work arrangements? Can you identify that for us, Steve?
Sure, and I think that the big thing is that there's a series of trends that are driving this, and a series of trends that are converging, and while each trend in its own right is powerful, when you get the convergence of multiple trends, that's when you start to see major shifts, and that's what we've seen in this independent worker thing over the last couple decades. And if you look at it, some of the key things that are driving it, demographics is certainly a major driver. Aging baby boomers are looking for alternative work styles than what they've had traditionally. The new generation entering the workforce, the Gen Yers, also called millennials, they're 20-somethings, are also looking for more flexibility, more work-life flexibility than people have had in the past. And so we've got these demographic trends going on that are driving it. There's also a series of social shifts around wanting to have more control over your career. And so we have kind of on one side these demographic social shifts that are leading more people to say, gee, it'd be good to be independent. And at the same time, traditional employment is looking less attractive. And most people who make this decision go through sort of this mental calculus of a job versus being independent. And historically, the power of a traditional job has been predictable income, security, stability, and benefits. And if you start to look at what's happened over, particularly since the last recession, job security is way down, benefits have been cut, stability is certainly gone. Even predictable income has become harder in the traditional way of work. So suddenly it's much less attractive to be a traditional employee, and at the same time these people are more interested in flexibility. And then you layer in technology, making it cheaper and easier to become an independent worker. In our surveys and interviews, very few independent workers spend more than say $5,000 setting up their business. And if I go back 10 years or so, particularly 15 years ago, those numbers were 4 and 5 times that amount.
Yeah.
And so it's just gotten cheaper and easier. And then bringing that all back together, it's kind of interesting. A major social shift that people underestimate is it's now become not only acceptable to be an independent worker, but it's actually desirable from a social standpoint. And so when I went independent many years ago, my mother was convinced that I was unemployed. My neighbors thought I couldn't get a job. It wasn't socially acceptable to be independent. Yeah. And now I'm working from home. They see that I have clients around the world, that I actually can afford my mortgage and I can eat. My mother still thinks I'm a drain on society, but everybody else is kind of jealous of the fact that I have this work flexibility. And so,
mother knows best, right?
Yeah, and so we've reached the tipping point where people are saying, gee, I'd really like to have that lifestyle.
Yeah.
And then the last piece of this, of course, is companies are hiring a greater percentage of their total workforce. They're moving more towards using contingent workers and independent consultants. And for them, it can be cheaper, but in our work, it's really around flexibility and agility and access to specialized talent, and also the ability to scale up and scale down quickly and efficiently is really the drivers for businesses. And when we talk to businesses today, particularly small businesses, the thing that scares them the most is fixed costs, because they're just, it's just so tough to predict what your revenue is going to do. And people have become viewed as fixed costs. And by shifting to a contingent worker, you shift those to variable costs. And so what we got is a much more attractive to companies to hire independent workers, much more attractive for people to be independent workers. You bring those two trends together, and that's why we're seeing the surge in the numbers.
Yeah. Now, I'll just throw in a couple of other stats. There was some interesting data that came out of our State of Independence research that Steve had participated in, and we've released for the last 2 years. One of the things that I thought was interesting is this whole idea of baby boomers being a big part of that demographic, but also the fact that the Gen Xers are growing at a rapid rate, choosing to go independent. So that's perhaps an evolving trend that the people of that age, that 40-something established in their career, have a good network, have new tools that they've learned to use, are empowered to be independent. So that's an interesting thing. Some Aberdeen research that just came out, it should be released relatively soon, shows that literally 80% of major corporations' independent contractors are Gen Xers. So it's a growing and influential part of that workforce, and can't really forget that.
Yeah, those people that, the Gen Xers are sort of right now in their mid-30s to late 40s, and they've come in age during a period where they were able to establish themselves in their industries, build their networks, and have the financial capability and the networks and the skills to go out on their own. And they are out there in large numbers. And
saw their boomer parents. Their boomer parents lose their pensions and maybe lose some of their 401k in 2000. So these are some of the things that I think as we as employers or as businesses accept the independent contractor movement, need to start accepting that this demographic has a whole different attitude towards work in general and how work gets done. So what challenges do you think an IC commonly faces when they make that big leap to independence? Anything come to mind?
Oh yeah, the biggest thing that they face is the lack of a predictable income. which is a huge challenge, and particularly when you start out, you're not really sure, am I going to be able to generate revenue? Am I going to be able to generate revenue at a level that will keep me happy? That's always listed as the #1 challenge. People are concerned about the lack of predictable income and the difficulty associated with getting work. After that, benefits do come up. Lack of job security certainly comes up as challenges that they face. But as I said, one of the things that we found most interesting is a growing percent. In the last survey we did as part of the state independence study, 39% actually said they felt more secure being independent than having a job. And the reason is, when you go and dig under the hood and interview these folks, they'll tell you, yeah, my income's not predictable, but it's not going to go away entirely. And I usually have, I have multiple customers, I got multiple revenue streams, and my job isn't going to disappear because of a capricious action by some faraway headquarters or some incompetent boss. And we usually hear those words, faraway headquarters and incompetent bosses, as things that people don't like about traditional employment. So there are definitely challenges associated with going independent, and I would add, there's in a number of industries and in a number of jobs, particularly lower paying jobs, the independent work also comes without legal protection, and those folks are often, frankly, mistreated. And so we're hoping for better enforcement at that level. But for the folks that like it, and our research shows, when you really get down to it, about half the people who are independent really like it, about a quarter of the people dislike it, and about a quarter of the people aren't sure.
Yeah, they're dealing with it. Yeah.
Yeah. So not everybody's in love with it. Not everybody hates it. But for the folks that like it, they see it as a vastly superior alternative to traditional employment. Now, on a personal note, I've now been independent for over a decade, and I've long since lost the ability to go work in a traditional job. I would just miss the flexibility.
Yeah, and that is it. Lifestyle choices certainly have come into play, and I think that's a lot of the driver as well. One thing I will say that we hear from our independent consultants quite often, the higher level independent consultant with a large, well-established network loses a lot of that fear of instability, or for that matter, income, and perhaps is having the difficulty of choosing which clients to work for as opposed to not having enough clients. So they often take on other team members that are also independent contractors to help them get their workload done. So interesting dynamic that we're watching evolve right in front of us. So let's move to kind of a wrap-up topic and see if we can't get a couple of interesting comments out of you guys that I think are starting to evolve from this discussion. One thing that we talk about here at MBO is the passport for independence. This is the whole idea that, so much of what we're seeing is a convergence of many, many factors: increased use, regulatory enforcement, all of the dimensions of demographic changes that Steve brought up. Is there something, and do you foresee the government making changes to accept more opportunities for independent workers? Are you seeing any kind of action being taken by the government to make it easier for independents to work with their clients, or is it going to be left up to private industry to figure this out so that they could take advantage of this workforce as well as do their best job to get their work done effectively? So let's start with maybe Eric. What do you think? Is there any chance the government's going to make some shifts here to support these small independents?
Short answer, no. Long answer, Steve did, I thought, a great job of articulating the whys of why businesses want just-in-time delivery of exactly the right tool for the job, why independent consultants for demographic and technological and other reasons are preferring, in many cases, to be engaged, to be independent. But and I've gotten this wrong in terms of my predictions historically. I've seen this irresistible force, immovable object clash, the government's desire to funnel everybody towards employee status and the growing business drive and consultant drive to be independent. And I've predicted that sooner or later the government would squash the drive to independence, and I've been wrong. The percentage of the workforce that's been independent has gone up and up and up and up inexorably despite more and more pressure. When the government, let me back up. When there's people, when you say the government, depends on who you talk to. There are people within the government who would listen to what Steve said and say, I get this. This is the way for the United States to be more agile, to be more entrepreneurial. A lot of our wealth in our country is being created by small entrepreneurs. We need to enable them and not squelch them. But there are people who are just as sincere in their beliefs who listen to Steve's articulation of why be independent and say, hogwash. I don't believe any of it. Businesses should be hiring these people as employees, and the only reason they're not hiring them as direct hire employees is because they want to oppress them. They want to deprive them of benefits. They want to cheat the government out of taxes, and they want to deprive the workers of protections that they would get if they had status as employees. And you can come up with anecdotes or statistics all you want, and there is a flavor of person in the U.S., many of whom are in government, who aren't going to believe it. They're going to believe this is a dodge. And organized labor among the different stakeholders in our economy just will not believe you when you tell them that we're engaging an independent consultant rather than a direct hire employee for this reason or that reason, and they won't believe the consultant when the consultant says, no, this is what I want, I'm not oppressed, this is the way I want to work. And there's a variety of political and economic reasons behind that, but the fact is that pressure towards funneling people towards W-2 status isn't going to go away in the foreseeable future, largely because of the power of the plaintiff's bar, the legal bar that wants to litigate all this, and organized labor that in its heart, and I'm not accusing them of bad faith, but in their heart, they believe this is a dodge. So the current political climate in this country is towards more protection for workers, and it's not. I just can't see anything happening with the current administration and Congress that's going to make it easier to engage people independently.
Steve, do you think that from a small business standpoint that there is sort of an acceptance that it may be difficult, it may be something we have to endure, but heck, I'm going to do it anyway, and all the idols that I see in business from the originators of some popular app or game or entertainment piece, these are the people that they aspire to be, and not necessarily the director of HR or procurement or accounting at the largest firm in town. Are you seeing that as let's say, a more common sort of shift?
Yeah, I mean, we're obviously seeing more and more people want to be independent. We're also seeing in the small business space, more small businesses recognize the benefits of hiring independent workers. And they've lagged, historically they've lagged larger firms in terms of their use of independent workers, but they are now catching up. And I certainly agree with Eric that the government's never going to like this. We have seen particularly in the last 4 or 5 years, a pretty big change in D.C. in terms of their attitudes about independent workers. You go back 4 or 5 years, and any place we went in D.C., we were told independent workers were bad. Bad for the economy, bad for the worker, bad in general. And now, at least we occasionally hear, well, they're not necessarily good, but they're not bad. And occasionally we even hear they're good. And so we've seen a change in Washington, but and in a way that leads me to believe they're becoming more positive towards this. And I think it's more that they're just accepting it, that it's a reality. But I agree with Eric. They're certainly gonna be kicking and screaming the whole way, and we shouldn't expect anything from the government helping. But I also think this is a case where there's not a whole lot they can do. And private industry will continue to move in this direction, and employees themselves, people themselves will move in this direction. and I don't think it's something that the government can stop.
All right, so let's get a wrap-up comment from each of you, and this has been great, good, factual, and relevant information. I think I'm happy that we've gotten the chance to talk about this stuff. So first of all, I'm going to give you guys sort of the view that we see all the time. We get a chance to talk to CEOs and CPOs and senior directors at large organizations, and many times we get this sort of glassy-eyed look that says independent workers, yeah, we probably have a few, but it's not a real big factor. And I think they're avoiding, in a sense, what might be an inevitable situation in their firm coming to the future. So if you were able to talk to a CEO for a 1-minute piece of advice, and they're not necessarily taking this movement seriously to include or to factor into their future workforce plans, what would you say to them, Steve?
I'd stress flexibility and agility first and foremost, because those are the things that CEOs care about right now. The fact that they're variable cost, everybody's trying to cut their fixed costs, and particularly in industries and areas where things are already heating up competition-wise, it's a way to access specialized talent that you likely are not going to have access to. And a lot of companies today that are really struggling finding really good high-tech programmers, Ruby on Rails programmers. I'm getting a little geeky here, but and frankly, the only way to access those for a lot of companies right now is to use independent workers. And so, as the war for talent increases, and in a lot of sectors, it's already very hot. I live out here in Silicon Valley, where it's just unbelievable how hard it is to come up with good programming talent. Independent work's the best way to go. So those would be the things I would focus on with a CEO.
I spoke to a recruiter fairly recently. This is a recruiter that's been recruiting technologists for 25+ years, and said to me, applications developers for mobile apps is 100% independence. You don't find anybody employed by a company. And he said the gamers and many other segments are literally going 100% independent. So it can't be ignored if you're certainly in any of those budding industries that are more or less taking over. Eric, what would you say to that CEO who's not taking it seriously?
Well, if the question is, do we engage independent consultants or not, if you make the decision you're not going to engage independent consultants, the farther you go up in the food chain in terms of skill level and uniqueness of skill of the consultants, the less likely it is that you'll be able to engage the talent that you need. Because the more particularized the skill is, the more likely it is that the consultants you want to engage won't be engaged as employees, period. That's a long discussion for the why, but the fact is you're knocking yourself out a lot of the market. Second, given the reality that you're going to be engaging independent consultants, I would urge, and I urge my clients to think outside of the box and not engage in procurement in the way you've done it just because that's the way that you've done it. A lot of times my clients' own policies and procedures and contracts get in the way of their engagement of talent. We've got a contract that you have to sign to engage talent. That contract has bells and whistles in it that make it impossible to engage contingent talent, also make it very difficult to engage talent in a way that gives us a fighting chance to argue that they're independent contractors. We may, in fact, not be exercising very much control over someone, and on the facts of the case, we might have a good argument that somebody should be engaged as an independent contractor, but we've got all kinds of terms in our contract and in our statement of work that reserve to us all kinds of control over when, where, and how to perform work, and rules that have to be followed for the person engaging, performing the work, that we really don't ever use or hardly ever use, and that by documenting them, we make it very hard for the Eric Rumbaughs of the world to successfully argue that this person is an independent contractor. So if we're going to be serious about correctly engaging independent contractors, get smart about how we do it. As I said earlier, you do not have to play the ball where it lies. You can kick the ball. You can deal yourself whatever cards you want. You can create the playing field that you want now so that if the Department of Labor or the IRS or a state unemployment agency calls you on it, you've already stacked the deck so that you get the result that you want.
Great. I'll just throw in my one piece of advice to a CEO. If you're not taking this seriously now, wake up. Everybody below you is, and you better start taking matters into your hands for your company, because it is going to be an effect that you're going to see certainly in the next 1 to 3 years. Thank you, gentlemen. Been a great chance speaking with you and getting your input. Thank you, everybody, for joining us. I'm sorry we're out of time at this point. So, again, Steve, Eric, I appreciate your input on this. And for those that are listening, we have a third webinar series coming up in a couple of months, and it's going to be titled, So You Want to Become a Compliance Officer. Give yourself some time, absorb that for a couple of months, and then join us in that webinar and see if you want to get involved in being the compliance officer for your firm. But we'll tell you how to do it. It'll be up to you to decide whether you actually take it or hire MBO to do it. All right, everybody.